Silence or stare. Just one question and answer.
Good afternoon. The inquest into the deaths of 19 residents of Newmarch House residential aged care facility are listed for directions hearing this afternoon. Let me just begin by taking appearances in the applications for leave to appear. Firstly, Mr. Buchan.
Thank you, Your Honour. I appear to assist Your Honour with my learned junior, Mr. Harris, Jake Harris. Thank you.
Thank you. Also on screen, Ms. Richardson.
May it please the court, with Your Honour's leave, I seek to appear on behalf of Anglicare Community Services, the operator of Newmarch House.
Thank you. You have that leave. I can't see on screen, but understand that Mr. Fordham is appearing. Mr. Fordham, I'm told by persons in court that you are connected. Just wondering whether or not you can indicate whether you can hear and see things from the court's end. All right. We might return back in a moment. Meanwhile, on screen, Mr. Palfrey.
Good afternoon, Your Honour. With leave, I appear for the Aged Care Quality and Safety Commission today.
Yes, thank you. You have that leave. I can't see on screen any other legal representatives. Is anyone else appearing for any of the other sufficiently interested parties?
Yes, Your Honour. May it please Ms. Robertson, I seek Your Honour's leave to appear on behalf of Colette Dixon.
Thank you, Ms. Robertson. You have that leave.
May it please, Your Honour.
May it please the court, Your Honour, Ms. Mack from Clayton Utes. We seek Your Honour's leave to appear on behalf of the Commonwealth as represented by the Commonwealth Department of Health.
I'm sorry, I just missed your surname. The audio was breaking up as you were speaking.
Apologies, Your Honour. My name is Mack, M-A-K.
Thank you, Ms. Mack. You have that leave also.
Thank you, Your Honour.
May it please the court, my name is Slan, S-L-A-N, initial C, and I appear with leave for and on behalf of a number of the family members of the late Leonie Corrigan, Victor Stone, Anne Fahey, Margaret Sullivan, and Alice Bacon.
Thank you, Mr. Slan. You had that leave as well. I just saw on the screen that Mr. Fordham left the connection. Hopefully he'll be rejoining it shortly. So we'll just wait momentarily and hope that he's able to do so.
Your Honour, we were able to speak with Mr. Fordham on the phone. He's, as you anticipated, he's tried to reconnect, and if that's unsuccessful, he's going to try to phone in with the phone link.
Very well, thank you.
Hello.
Mr. Fordham.
Yes, Your Honour, I'm sorry. I was on screen but couldn't be seen or heard.
Not at all. The audio is coming through quite clearly now, so that appears to have at least resolved the issue from the audio end.
Thank you, Your Honour. I seek Your Honour's leave to appear in the interests of the Ministry of Health and the Nepean Blue Mountains Local Health District. I appear with my learned friend, Mr. Fraser.
Yes, thank you. You have that leave. All right. Turning firstly to Senior Counsel assisting Mr. Buchan, understand that the directions hearing has been listed today to hear an application by Mr. Fordham on behalf of his client, and also to deal with some administrative matters ahead of the current listing of the matters for hearing.
Yes, Your Honour. The primary reason why the matter has been listed before Your Honour is so that the application that is to be made by Mr. Fordham can be heard, but it is also a timely occasion to raise in an open way practical difficulties with the inquest commencing in the scheduled October timeframe, if not the viability of it doing so.
Thank you. I'll turn to Mr. Fordham in a moment in order to deal with the substantive application, and then afterwards hear from the remaining legal representatives and Senior Counsel assisting. But before I do so, let me just say a few things by way of opening remarks to the families and loved ones of the Newmarch House residents who I understand are joining the directions hearing remotely today. So to the families and loved ones of Alice Bacon, Blanche Billinghurst, Margaret Brocklehurst, Edith Brownlee, Leonie Corrigan, Anne Fay, Ronald Farrell, David G, Olive Grego, Maria James, Barry Jahan, Raymond Jennings, Faye Rendoth, Keith Smith, Victor Stone, Margaret Sullivan, Marko Vidakovic, and Shirley Yates. Let me introduce myself, because this is the first opportunity that we have had to meet, albeit in a virtual way. My name is Derek Lee. I'm one of the Deputy State Coroners for New South Wales. I wanted to begin by passing on my personal condolences and those on behalf of the Coroners Court of New South Wales to you all for your tragic and sad losses, and also those condolences extend to families, loved ones and friends who have been deeply affected by those lost loved ones and who are unable to participate in the directions hearing today. Secondly, let me express my thanks and appreciation for engaging with the coronial process and with the coronial investigation, and for participating in today's directions hearing, albeit in distressing and upsetting circumstances. And lastly, as you've heard me say a moment ago, part of the purpose of today's directions hearing is to ensure that a number of practical steps are taken to make certain that the inquest proceeds in a way which you would like them to proceed, and also to ensure that each of you are also given a voice in that process. So thank you once again for participating and remaining engaged in the coronial process, albeit in very difficult circumstances and made more difficult by the fact that today's hearing is obviously being conducted remotely. So thank you very much for that. All right, turning to some of the substantive matters, what I propose to do is to hear from Mr. Fordham first regarding his application, and then to hear from Senior Counsel assisting, followed by hearing from submissions from the legal representatives of the other interested parties, and then return to Mr. Fordham and Senior Counsel assisting for anything in reply. Would that be a convenient way to start, Mr. Fordham? Mr. Fordham, are you still on the connection?
Yes, I am, Your Honour. I apologise. I can perhaps shorten things. We've been sent a proposed witness list for the first 2 weeks of the hearing, and if that is the witness list that is adopted, and subject to a couple of other things that I am about to say, we do not press the application. The witness list doesn't include any frontline New South Wales Health, Ministry of Health or Nepean Blue Mountains staff, which was our concern. And in those circumstances, whilst I will have some difficulties obtaining instructions, given all the competing rights and desires, we've taken the view that we won't press the application. That's subject to a couple of things. The first is that I understand there is yet to be further expert evidence, and that may or may not cause me a difficulty. I do not know. And the second thing is that whilst it is my invariable practice and the practice of those that I represent to be as reactive and of as much assistance as is possible in any given circumstance, we are in a position where it will be difficult for us to be reactive at the current time, simply because whilst we hope it is not the case, the predictions have been that the health system may be under some stress. Who knows? We hope it's not, but I don't want to make promises I can't keep.
Thank you. Yes, I understand. All right. In that case, Mr. Buchan.
Thank you, Your Honour. First of all, can I just remind those listening that there is a non-publication order in place that was made earlier this year in relation to the name that's presently covered by a non-publication order. Your Honour, I thank Mr. Fordham for outlining his changed position in terms of now not pressing the application. And further, by way of background, the council assisting team acknowledges that some of the interested parties in this matter would generally prefer for the inquest to commence sooner rather than later in a timely manner. It's our understanding after the consultation that we've had and that we've conducted that there is a diversity of views amongst, in particular, the family members, the family of the deceased. But the following views have been conveyed to us in a fairly consistent way. Firstly, that while there may be a desire for the inquest to commence sooner rather than later, there's also a strong desire, as you would understand, that the inquest be conducted in an effective and probing manner. Secondly, certain families have expressed the view that if at all possible, they would prefer to be able to attend in court in person rather than to participate in the inquest virtually in the way that's occurring at the moment. And one can well understand that desire. That doesn't just impact on the immediacy of their experience, but it also permits family members to be together while the inquest is proceeding, to be able to support each other rather than effectively being isolated in various locations from which they'd be viewing the proceeding. The third view that's been expressed is that, again, while families would like the inquest to commence, they certainly don't want to do anything that would place the health system under greater pressure, place greater pressure on doctors, on other relevant agencies in dealing with the present COVID outbreak. And it's well to remember that we're presently in the grip of an outbreak, and there seems to be at least some prediction that's been made in various fora that October is likely to be the period in which the system is under greater strain, potentially mid-October, which is exactly when the inquest is scheduled to commence. So I just make those observations by way of preliminary remarks. In terms of court dates, there has been a development that the party should be made aware of, and that is that it appears that there is now the court only has 1 week available in October, not 2. That week is the week beginning 11 October. That's the week that we understand is available to Your Honour, who has come into this inquest fairly recently. In other words, that second week in October is no longer available. That would then leave the remaining time listed, the week beginning 22nd November, and then there are 3 days in February, 9 to 11 February. Now, what's clear there is that there are significant breaks, significant periods of time between these hearing tranches, and that is going to introduce, in my submission, inefficiency into the process. That is going to be a less efficient process than if the inquest were able to be given dates further afield, a consolidated hearing block. I also express this concern. Your Honour has heard from Mr. Fordham that a witness list was circulated as part of the contingency planning based around what might happen. And Your Honour appreciate this is an evolving situation that we're in. But I'm not at all confident that that evidence could be dealt with in the week in October. The evidence that's on that witness list that's been sent around, and those witnesses who are on that list fall into the category, first of all, of family members who wish to give evidence, then certain Anglicare staff, particularly those staff who are on the ground, as it were. Then there are some witnesses drawn from the Surge workforce, from the Mabel and Aspen organisations, and finally 2 witnesses from Baptist Care who came in to assist at a certain point in time. Now, that was the contingency planning in relation to the witnesses that we might start with, given other problems that I'm about to go into with the expert evidence. But I should make this clear. I don't believe that could be dealt with in the week in October. And assuming that we can get through all of that evidence in the 2 weeks, that leaves quite a bit of the important evidence for dates further afield. And I'm concerned about the way that will work, given the inefficiencies of dealing with an inquest across these significant gaps in time. My view is that the inquest would run far more consistently and efficiently and intelligibly and effectively if it's dealt with in a consolidated block of time, which unfortunately does not appear to be available in the latter part of this year. That then brings me to the issue of expert evidence. Those who are instructing me have been making valiant efforts during the current COVID situation to obtain relevant expert evidence. And by virtue of the nature of the issues that this inquest involves, it should be appreciated that there are a number of areas of expertise that will be drawn upon. Those efforts have commenced many months ago. Out of 55 experts that were approached in the first instance, 9 came back expressing interest. And that was primarily due to potential experts being busy dealing with a health crisis. The current state of play is this. The final reports of 3 experts have been served as part of the brief of evidence. They include Associate Professor French, who is an intensivist, Professor Susan Curl, Kurrle, who's a geriatrician, and Associate Professor Kotsimbos, Kotsimbos, who's a respiratory physician. But there are reports outstanding. At the moment, there are 3 reports that we expect to receive outstanding. One is from a geriatrician and public health expert, Professor Ibrahim. Another is from Professor McIntyre, who's an epidemiologist. And finally, we also expect to receive a report from Dr. Bernard Hudson, who is the head of infectious diseases at Royal North Shore Hospital, who will bring important clinical knowledge to bear on the inquest. It is far from ideal that those conducting the inquest do not have those reports to hand at this late stage, and that is almost wholly a reflection of the difficult circumstances that I explained in terms of obtaining those reports and the very understandable position in which the experts find themselves having to deal with the present COVID situation. The provision of expert reports, if that is to occur before the October dates, assuming that we get those reports finalised and we're able to obtain them and serve them as part of the brief, as a supplementary part of the brief to the various interested parties, even if we have that material before the October date starts, which is not certain at this stage, we hold concerns. We hold concerns about the fact that the council assisting team will be deprived of the opportunity to properly assimilate that material and to formulate our approach to this inquest, at least in the first instance, as against that body of expert opinion. We're also concerned about the position that that will place interested parties in terms of being provided with such important evidence at a relatively late stage, so close to the commencement of the inquest. It's a matter that really does bear adversely on the conduct of the inquest in a material way. So I raised that concern squarely, and that's why I've taken Your Honour's time to outline those circumstances. I mentioned before that there have been various predictions made, and of course they're just predictions. There's always a degree of prognostication about such things, but there is that prediction sitting there that the health authorities will come under strain in October, particularly in mid-October. And I've listened closely to what my learned friend Mr. Fordham has said about the position that his client may be placed in and the way in which that may impact on his capacity to respond in a constructive way to requests for information made by those conducting this investigation, requests for statements, things of that nature. We are concerned that as the inquest proceeds, that we may not be in a position to receive information in a timely way from Mr. Fordham's client, who obviously is a very important interested party in this inquest. So that appears to us to be a further difficulty that needs to be given careful consideration. Finally, I wish to raise for all to consider, the potential advantages of the inquest being dealt with in a single hearing block. Next year, at a time when the expert evidence has been to hand for a reasonable period of time. Clearly, that will be a more efficient process. It will allow for a more effective inquest. There is a possibility that the hearing could be conducted in court rather than over the ABL. We don't know, but that's a possibility. If that were the case, clearly an in-court inquest would be a more meaningful experience for the interested parties, particularly the families of the deceased. You would also avoid the inevitable glitches and technological problems that will be associated with an online hearing. We've already had some today just in this directions hearing. And it's very important to us that the families get the most out of this inquest possible. That will facilitate that aim as well. So from our perspective, while it would be regrettable that the inquest couldn't start earlier, which is something that we would have liked to occur if possible, it may be that the benefits of a later start, but in more conducive conditions to a more effective inquest, is in the public interest. And I wish to raise that squarely for your consideration.
Thank you. What I'd like to do is just to add three things that have arisen from the submissions made by senior counsel assisting that will hopefully be of assistance to the legal representatives in putting forth their position so far as the future conduct of the hearing is concerned. The first is that it's correct that at the moment I have another matter listed for inquest in the week of the 18th of October this year, meaning that I'm only available at the moment in the week of the 11th of October. There is a possibility that that situation may change and that the second week will become free, but at this stage, that week is unavailable. The second thing is that if the hearing were to be vacated in whole or in part, requiring it to be adjourned in whole or in part to next year, then at present, the first availability that I have to relist the matter is in the week commencing the 18th of July 2022. That is a date that is at the moment available with certainty, although it is possible that arrangements could be made with the reallocation of other inquests to allow for these inquests to be listed before July. The third consideration is related to the matter raised by senior counsel assisting regarding the availability of expert reports and expert evidence. It would be my hope, in accordance with the usual practice and to afford the sufficiently interested parties procedural fairness, to allow an opportunity after service of those reports and completion of the final instalment of the brief of evidence, sufficient time to take instructions and to give consideration to whether or not applications will be made seeking amendments to either the draft issues or draft witness lists, and also to seek to add material to the brief of evidence. Those are the three practical considerations that I add to supplement the matters outlined by senior counsel assisting. What I might do is return to Mr. Fordham, see whether or not he wishes to say anything further, having heard what counsel assisting has just outlined, before turning to the other legal representatives. Mr. Fordham?
No, thank you, Your Honour. Although this isn't a matter for instructions, but I can see some merit in one tranche of hearing, so that all the issues can be dealt with in one go and there's some continuity to it. But that's my view as counsel, not necessarily as instruction. And that's really all I wanted to say. And the only thing I would say is that if the matter is to adjourn and be reallocated dates, it may be that the 3 weeks that's currently listed for are insufficient, given what appears to be the likely witness list. That's all I wanted to say, Your Honour.
I see. Very well, thank you. Turning next, Ms. Richardson.
Thank you, Your Honour. I accept that the ground has shifted slightly given what's fallen from Your Honour and the senior counsel assisting today. But my instructions on behalf of Anglicare Community Services is to still press for the hearing to proceed in October, in essence for the reasons set out in our letter to the court and copied to the DCJ on the 21st of September. The particular interest my client has, and I must admit we proceeded on the basis that this would also be the position of the families in terms of wanting to have this matter heard as soon as possible, is that the delay in my submission will cause hardship to the staff of Anglicare who have been preparing on the basis that they will be giving evidence. And as my learned friend indicated, the witnesses on the draft witness list were frontline witnesses who went through a very difficult period in terms of dealing with the events at Newmarch House last year. And so my client is particularly concerned about the adverse impacts on the mental health of its staff of ongoing delay. We had rather apprehended that the basis of the witness list in the fact that it excluded any Department of Health witnesses was designed to deal with the concern that the department had raised, which we accept is a very valid concern about having an inquest in the midst of a significant statewide outbreak that it was dealing with. And we certainly would not be advocating in favour of any option which put additional pressure on the health system. But in my submission, the proposal that seemed implicit in the and we optionality in terms of the draft witness list, but that option whereby no departmental witnesses are called is an appropriate compromise in the circumstances. We accept that now it's become apparent that Your Honour only has 1 week that the large number of witnesses on that list would not be reached in a week. But in my submission, Your Honour, in terms of the impacts on persons of delay, would prioritise calling of family witnesses who wish to be called earlier rather than later, and Anglicare witnesses, and that Your Honour would use the dates. In terms of the specific matters raised today, I know that Mr. Fordham in effect withdrew the application for an adjournment on the basis of the witness list that had been produced in draft. So I don't apprehend that in fact it's an adjournment application from the Department of Health. In that respect, even though Mr. Fordham understandably made a reservation in terms of whether his client would be as responsive as normal in terms of responding to requests for witness statements and so on, if the witnesses that were slated for that week in October were in effect Anglicare witnesses and family witnesses, it would appear extremely unlikely that requests would be made of the department in that week in any event, because a different topic was being traversed. In respect of the next point, which is the availability of expert evidence, a significant amount of expert evidence has already been served, as the senior counsel assisting outlaid. In respect of the few outstanding reports, counsel assistant acknowledged that there might be difficulties to interested parties in terms of digesting that material if it was served close to the hearing. Anglicare's position is that it's happy to accept the potential for those difficulties in order to, because the greater interest is getting on with the inquest and avoiding further delay. In terms of the desirability to have a block of dates rather than a sequenced set of hearing dates, we accept that all other things equal, it would be preferable to have a block of dates. The difficulty is in relation to the ongoing pandemic is that any delay in my submission raises the prospect of creating further knock-on delay, and in circumstances where the parties have been preparing on the basis of October dates and the key interested parties do not oppose those dates proceeding, that although it's not ideal, it is preferable to continue and take the dates that are available in order to commence the process of inquiring into this matter. The alternative where the only block of dates is July of next year in my submission is would be regrettable in the sense of it's more than 2 years after the events and a further, in effect, 9-month delay from now. So for those reasons, in my submission, Anglicare submits that the weaker dates in October should be taken up so that the inquest can commence. May it please the court.
Thank you. Turning next to Ms. Robertson.
Well, Your Honour, I have no difficulties with the new dates in July if the court pleases to reschedule the matter.
All right. Thank you. Mr. Slan, did you wish to say anything in relation to what's been discussed this afternoon?
May it please the court. The instructions that I have from the family were in relation to the initial application as opposed to what's been suggested by counsel assisting, but the position of the families initially in relation to the application was to be that we're in the court's hands as to what the court considers is appropriate, whilst the parties would prefer for it to be dealt with sooner rather than later. The parties also understand the difficulties given the current circumstances and the current COVID outbreak. And so whilst I don't have instructions on it, I consider merit in some of the proposals made by counsel assisting, both in relation to it being dealt with in one tranche and also in relation to the potential possibility that it may be conducted in person. I don't have any instructions in relation to the matters that have been raised today, but we're in the court's hands as to what's suitable and what the court considers the most effective and efficient process to allow the issues to be dealt with and dealt with in the most efficient way for the families and the court.
Very well, thank you. Ms. Mack, did you wish to say anything in relation to what's been raised this afternoon?
Yes, thank you, Your Honour. I'm also in a position where we had instructions with respect to the application to adjourn that we now understand is no longer being pressed. However, I can indicate that the Commonwealth is in a similar position to that of New South Wales Health insofar as the availability of its witnesses and its instructors is impacted by the ongoing COVID-19 outbreaks in Australia. And so while we have not had an opportunity to take specific instructions in relation to the additional matters that have been raised today, I think we can say simply that we'd be in the court's hands with respect to the rescheduling of the inquest, but otherwise, would have been in a position to indicate that the Commonwealth's preference would be for the matter not to proceed or for its witnesses certainly not to be called in that first tranche of October dates.
Yes, thank you. And Mr. Palfrey, is there anything that you wish to add to the discussion?
Not really, Your Honour. Our instructions were to neither oppose nor consent to the application that was not pressed today, and I don't have specific instructions on the matters raised today apart from to say that that position probably remains, that it's a matter for the court.
All right, very well, thank you.
Thank you.
Just returning lastly, Mr. Buchan, anything further to add to the discussion?
Yes, Your Honour, just briefly in reply. First of all, noting what the learned friend Mr. Fordham said about 3 weeks potentially being insufficient, notwithstanding the greater efficiency of conducting the hearing in a single block, there is a real possibility that the evidence would go into a 4th week. So I should note that. Note of agreement with the concern that Mr. Fordham raised. Secondly, just responding to some of the submissions made by the learned friend Ms. Richardson. It was said that it's extremely unlikely that requests will be made to New South Wales Health in relation to the October hearing tranche. We on the counsel assisting side are not so confident of that extreme unlikelihood. The issues in this inquest are interrelated. It's very difficult to quarantine issues according to the different bodies of witnesses, such as families or Anglicare workers on the ground, etc. That being the case, we do see that there is a real possibility that requests for information might need to be made. And that's a situation that might well impact, if not on the October dates, then the November dates. Let's say, for example, that requests for information are made during the October hearing or shortly afterwards in preparation for the November dates. That may similarly be a time when the New South Wales and Commonwealth authorities are compromised in their ability to respond in the way that they would constructively, no doubt, like to respond. Thirdly, I acknowledge what Ms. Richardson has said about some expert evidence having already been served, but there's still substantial expert evidence outstanding. And it's hardly optimal that we're in that position. And that does adversely impact on the council assisting team's capacity to properly prepare this inquest. And unfortunately, that may then have a flow-on effect to Your Honour's preparation of the inquest. Finally, or penultimately rather, notwithstanding that Anglicare is prepared to effectively live with the consequences of later service of outstanding expert evidence in the interest of obtaining an earlier hearing date, other parties haven't expressed that view before Your Honour, so you should take that into account. There seems to be a broad consensus, judging by comments or submissions that have fallen from the various parties, that a consolidated hearing block is preferable. To pick up on a word that Mr. Fordham used, it will allow for greater continuity. It will allow for greater efficiency. It'll make the inquest more effective. And in my submission, that's a significant matter. Finally, for the reasons that Your Honour has outlined, we don't have 2 weeks anymore in October. That means we won't get through even that first body of evidence. In the first week, there'll need to be that interruption, that significant delay before the November tranche. So even on the current best attempt to get the inquest moving earlier, there are going to be substantial interruptions which will draw the thing out. And I note in that context what my learned friend Ms. Richardson has said about the mental health of those witnesses that are related to the party instructing her. So that matter should be taken into consideration as well. The impact of a consolidated hearing block, the adverse impact on the mental health of those affected, that will have its advantages over a drawn-out inquest, conducting hearings in a piecemeal, fragmented way over a substantial period of time. Thank you.
Thank you. Just give me one moment.
Your Honour, could I just say one further thing which I forgot to note? I apologise, and I accept this is a way smaller matter in the scheme of things. I have limited availability in July of next year, and I have been involved in this matter for some time.
Yes, thank you. Just by way of background, a series of concurrent inquests into the deaths of 19 residents of Newmarch House Residential Aged Care Facility are currently listed for hearing in the weeks of 11 and 18 October, 22 November, and between 9 and 11 February 2022. By letter dated 14 September 2021, one of the sufficiently interested parties, New South Wales Health, raised for consideration and foreshadowed an application seeking adjournment of the current hearing dates to a later date, or at least consideration of deferment of the October hearing dates, where evidence was expected to be taken until the November hearing dates. On that basis, the other sufficiently interested parties were advised of that anticipated application, and in response, the parties have provided views ranging from opposition to the application on behalf of Anglicare to other parties effectively adopting a neutral position. On the basis of the 14 September letter, the matters were listed for directions hearing today so that the application could be heard and determined, as well as give consideration to other practical matters affecting the conduct of the series of inquests. This afternoon, Senior Counsel for New South Wales Health and Nepean Blue Mountains Local Health District indicated that effectively that application would not be formally pressed, whilst acknowledging that if the hearings were to proceed in their current form, it would likely impact upon the capacity of New South Wales Health to be responsive to any requests made of it arising from issues which the inquest would likely examine, and to be assistive in relation to any such responses. That means that the matters that were for determination effectively have fallen away in a substantive sense, but other matters have been raised this afternoon, many of which are related to the purpose behind the original application that require consideration. The first is the matter that I've just mentioned, that is the capacity of New South Wales Health and its witnesses to prepare for the inquest and to respond if called upon to assist or provide information in the period leading up to the first hearing dates, and obviously during the course of them. The Commonwealth Department of Health has raised that they would likely be in a similar position regarding the availability of its witnesses and their capacity to respond if similar requests were directed towards that organisation. Over the last 3 months, a number of inquests have proceeded whilst the current public health orders have been in place and whilst the Greater Sydney area has been in lockdown. Those inquests have proceeded largely remotely in accordance with the current State Coroners Memorandum, COVID-19 Memorandum 4, and some of those inquests have involved either New South Wales Health or local health districts as sufficiently interested parties. I know firsthand because I have conducted a number of those inquests. It is correct on the one hand to say that those inquests have proceeded, but on the other hand, it is not possible to accurately measure the impact that those inquests have had behind the scenes in terms of their impact on health, local health districts, and indeed other parties to manage and conduct an inquest in the face of the current public health orders. The other consideration is that whilst those inquests have indeed proceeded, they have not been to the scale or complexity that is anticipated that these series of hearings proceeding concurrently would involve. Therefore, in my view, the concerns that have been expressed, whilst not explicitly in relation to a formal application to vacate the hearing by New South Wales Health or any party, raises some legitimate concerns in relation to, firstly, the capacity for New South Wales Health to respond and assist the inquest, and secondly, the impact that that might place upon the public health system and managing the current COVID-19 pandemic and outbreak. Set against those matters, Senior Counsel for Anglicare has identified that a draft witness list dated 27 September this year does not list any New South Wales Health witnesses, and therefore the likelihood of health or the local health district being compromised in their capacity to assist is minimised. However, my view is that whilst there are, in general, some advantages to dealing with hearings by adducing evidence in tranches, this is not a matter, or these are not matters which easily lend themselves to such a course. In my view, there is great difficulty in compartmentalising bodies of evidence, for example, factual evidence on the one hand, and executive level or agency response evidence on another, and expert evidence into a third category, so as to cause difficulties when attempting to receive one body of evidence without being able to make inquiry of evidence which relates to another body of evidence. Another consideration is a matter that has been raised by Senior Counsel for Anglicare, in the sense that if the October hearing dates were to be vacated, then that would cause difficulty for its witnesses and also witnesses in general, in the sense that those witnesses have been informed of the current hearing dates, have made preparations for them, have made preparations in anticipation for giving evidence, and that to adjourn the matters would be to cause difficulties in view of that preparation and anticipation. It's true that anxiety or apprehension felt by a witness in the context of any hearing is a common experience. But at the moment, there is nothing specific in relation to those matters which indicates that a particular witness is adversely impacted in a particular way. It's also accepted on the basis of the written response provided by the solicitors for Anglicare that there is a concern that if the hearings were to be vacated and adjourned until next year, then that would adversely impact upon the ability of witnesses to record or recall factual events. Again, it's accepted that the longer the interval between an event and an inquest or a hearing, the more likely it is that a witness's ability to independently recall events is adversely affected. However, in that context and in the general context in which hearings are listed and proceed in the coronial jurisdiction, it is not uncommon for hearings to proceed a number of months, indeed sometimes 2 years or more following an event. That is a reflection not of a unwillingness to proceed as efficiently and expeditiously as possible, but reflects the necessity to conduct a comprehensive coronial investigation, the time that it takes, and other practical considerations such as finding suitable dates for hearing that can accommodate coroners, legal representatives, witnesses, and family members. Applying those timeframes to the present matter, it's anticipated that the issues which the inquests will be examining will focus between March and June of 2020. Even if an inquest were unable to proceed either in whole or in part with the current hearing dates and would need to be adjourned until approximately mid next year, that would still mean that an inquest is held within 24 months of the dates of deaths. In the context of the coronial jurisdiction, that would not be an untoward or untimely time frame between event and hearing. Third, there are a number of practical considerations which have been flagged this afternoon that affect the current inquest date. One is that although the specific views of all the family members have not been sought or been able to be obtained, it has been indicated that there would be a general preference for the hearings to proceed in a way which would allow for family members to be present in court in person. Of course, that is now not possible given the current public health orders and the State Coroner's current memorandum 4. Although it is not possible to predict the ways in which those orders and memorandum may change, I think that it is possible to at least predict with some assurance that if the matters do not proceed at the present time when the current public health orders are in place, that there would be greater opportunity for the inquest to proceed not as a remote hearing, but as a conventional hearing, so as to allow family members and indeed witnesses and legal representatives to be in court. If that were the case, then it would allow for family members to support one another and give effect to what is always an underlying intention of the coronial jurisdiction, which is the therapeutic jurisprudence component of the jurisdiction, and also to reduce inefficiencies that may be associated with technical difficulties and the like. Again, I acknowledge that over the last 3 months, inquests have still proceeded remotely, but again, they've not been without their difficulties in terms of grappling with technology and other associated issues. Another practical consideration concerns completion of the brief of evidence. As Senior Counsel Assisting has outlined, there is still some expert evidence that needs to be gathered and completed and served on the parties. Whilst the majority of the evidence has been gathered so far, there's no doubt that that remaining expert evidence is of importance. While Senior Counsel for Anglicare has indicated that whilst there may be concerns about proceeding to inquest without the brief of evidence being completed or the likelihood of it being completed, the other parties may not have that same view. Certainly, from my view, it would be preferable to, in accordance with the usual coronial practice, to complete the coronial investigation, complete the brief of evidence, ensure that the final instalment of the brief of evidence is served on the sufficiently interested parties, and then to make directions to allow the parties sufficient time to consider that material, and then, if they wish to do so, make applications seeking amendments to either the witness list or issues list, and make applications seeking additions to the brief of evidence. Third, the way in which the current series of hearings is structured is that there are currently 3 tranches across a period of 5 months. As Senior Counsel Assisting has pointed out, that type of structure lends itself to inefficiencies in the conduct of the hearing, in the sense that at present, there is only 1 week available in October to deal with a current draft witness list that seeks to exclude New South Wales health witnesses, that witness list being or containing 33 witnesses. In my view, there are real difficulties in attempting to adduce evidence from all those witnesses, even if the hearing were to proceed in the week, or the first hearing week in October and then in November. If there was an inability to receive all of the evidence in those 2 weeks, then that would have the flow-on effect of placing pressure on completing the inquest in any remaining hearing dates, and also create further inefficiencies in terms of receiving the evidence in a disjointed and fragmented way. As has been mentioned a number of times this afternoon, ideally, in all circumstances, it would usually be preferable to receive evidence in a structured and consolidated way in 1 block of hearing dates. Having regard to all of the matters that I have outlined, it seems to me that there are more factors that favour vacation of the current hearing dates and seeking to find a consolidated block of hearing dates in 2022. I note that Senior Counsel for Anglicare has indicated difficulties if the hearings were to be listed in July of next year. That, of course, will be taken into consideration together with the availability of other legal representatives, witnesses, family members and support persons. And as I said at the commencement of the directions hearing, whilst that period in July 2022 is the first period with which I can indicate with certainty that is available, all efforts will be made to attempt to bring matters on for hearing earlier than that, if at all possible, subject to accommodating the availability of all those persons which I just mentioned. Therefore, what I propose to do then is to vacate the current hearing dates and to relist the matter on a date to be fixed. The reason why I propose taking that course is to ensure that appropriate inquiries can be made with the legal representatives, parties, witnesses and family members to find suitable dates, as well as witnesses, of course, and hopefully a consolidated hearing block. In order to ensure that that occurs and to ensure that the parties are given an indication or as much information as possible in relation to the matters I mentioned regarding completion of the brief and opportunity to seek amendments to the brief itself and the issues and witness lists, I would propose to bring the matter back for directions hearing at a suitable date. At this stage, I would propose that that be done in in 3 weeks' time, on the 19th of October at 9:30. Firstly, I'll just turn to each of the legal representatives in turn. Firstly, Mr. Buchan, any difficulties with what I've outlined going forward or with the proposed future directions hearing date?
No, Your Honour. That date is suitable to the council.
Right.
Thank you.
Thank you. Mr. Fordham, any difficulties with the path going forward or the proposed hearing directions hearing date?
No, Your Honour. Thank you.
Thank you. Ms. Richardson?
The director's hearing date is convenient.
Thank you. Ms. Robertson?
No difficulties, Your Honour.
Thank you. Mr. Slan?
May it please the court that time and date is suitable.
Thank you. Ms. Mack?
No difficulties, thank you, Your Honour.
Thank you. And lastly, Mr. Palfrey?
No difficulties, Your Honour. Thank you.
All right. Thank you. Just excuse me for one moment. All right. Well, in that case, then I will adjourn the matters to the 19th of October for further directions hearing at 9:30 and formally vacate the hearing dates of the weeks of 11 and 18 October and 22 November 2021. And the 9th to 11th February 2022.
May it please the court.
Please.
All right. Anything further this afternoon, Mr. Buchan?
No, Your Honour, not from us.
Thank you. Do any of the other legal representatives wish to raise anything further this afternoon?
No, Your Honour.
Not for my part, Your Honour.
All right. Thank you. Thank you to all the legal representatives for their appearances and assistance this afternoon. Lastly, to the family members who are attending the directions hearing remotely, you will have heard what's occurred so far as the immediate hearing dates for the series of inquests are concerned. Regrettably, it's not been possible to proceed in the way that was originally envisaged for the reasons that I've outlined, but it's hoped that by proceeding in a different manner, not only will that ensure that the series of inquests proceeds in a structured and efficient way, but as I also indicated, give effect and meaning to your participation in the coronial process and also the inquests themselves. Thank you again for remaining engaged in the process and participating in the directions hearing this afternoon. All right, very well. Thank you. I'll adjourn.
No, please.